everyone can see my face and see our slideshow. As a quick matter of introduction, I would like to thank the ACC for this opportunity to speak about a very important topic, something that is obviously very timely. And I am honored to be serving on the panel with a number of my partners from our other offices. We have Kat Carrington from our Jackson, Mississippi office, Mitch Morris from our Richmond, Virginia office, David Mahan from our Denver, Colorado office, and Tim Lindsay from our Jackson, Mississippi office. And as you can see, I'm the only South Carolina lawyer on the panel. And this is by design. A unique feature of Butler Snow, our firm, is that we work cooperatively within our footprint, within our offices, which stretch from Denver and Arizona on the western side through the deep south and up along the eastern seaboard up to New York. And when the coronavirus hit, our firm put together a coronavirus task force. And so Kat and Mitch and David and Tim are all members of this task force and have spent the last several months studying the effects of the coronavirus, both on litigation as well as other aspects of it. And so this multi-dimensional COVID task force that we've put together has really helped Butler Snow to adapt and to address the many challenges coming out of the coronavirus. Now, I'll tell you, when we were asked to speak on the coronavirus and COVID litigation update, it probably is no surprise that this is a very vast topic. There's a considerable amount of issues and different fields and practices of law that are included within this large category that we call COVID litigation. And so what we've tried to do in assembling this panel is to give you, the audience, a snapshot of several important areas of law that have been affected through this COVID litigation. But we are constrained by time, and we've only got a few minutes that we can each present on our various topics. And so if it seems like we're moving fast, it's because we have a lot to say and not enough time to say it. So I would encourage anyone that's participating on this call, if you have a question, please feel free to raise it during this presentation, or if we don't have time to get to it, you can contact any of the lawyers on this panel afterwards, and we'd love to have a conversation to follow up. But my role in introducing this panel, I'm going to take the first segment. What I'd like to do is sort of set the stage for COVID litigation in the United States and in South Carolina. I'd like to provide some statistics so that we can all kind of understand the scope and the breadth and the depth of COVID litigation. And as you can see from this first slide, there have been almost 5,000 COVID-related complaints filed in the United States. And they span all types of practice areas: property, torts, employment, insurance, education, all the way through civil rights. And so, you know, this is a pervasive issue that doesn't just affect one industry or one type of company. It really sort of spans the universe of businesses and entities in our country. And so one of the stats that I found astounding is when you look at this next slide, it shows the cumulative filings, which really began in early to mid-March. And you can see how this curve reflects just the sheer volume of cases that are being filed in the US. You know, and this is a curve, notably, it's not a parabolic curve. It's not a curve that appears to be diminishing, at least anytime in the near future. I think we can expect to see the trajectory of COVID-related filings to continue to increase as indicated in this slide. You know, I think it's important for us also to look at the types of industries that are affected. You can see based on this source from UPenn has a very reliable COVID litigation tracker, and they show that the food and service, food and drinks really operates the #1 target for COVID litigation. Then you've got healthcare services, other personal services, and on down the line, accommodation, of course, being hotels. And so, you can see based on this that really there is no industry in the U.S. That has been spared by the COVID litigation that has begun this year. Focusing on South Carolina, you can see we don't have a tremendous number of COVID-related complaints that have been filed. It's a bit of an unscientific study trying to come up with a reliable way to track COVID litigation, because it takes on so many different, different characteristics. But what we have done as a firm and in our South Carolina office is we've gone through and searched the databases and come up with a total of 27 in South Carolina. And they include the following, wrongful termination, the loan processing, COVID testing, education, business interruption, and recreation and leisure. And so looking at just taking a quick view at a few of the cases that have been filed in South Carolina, I'll note that they're all in federal court. You can see we've got this first case was had to do with student access to remote learning, filed against a school. The second case that we have here is a class action that's alleging breach of contracts against Air China for arising out of flights that were canceled due to COVID. You can see here we've got the Coconut Joe's case is a wrongful termination case. The Heartwise case is a breach of contract case arising out of COVID testing and the facilities that were providing that. You can see the P and Associates case. This has to do with the handling of the PPP loans. And we'll get to the P and Associates case, as well as this large number of Ratliff CPA firm cases. They all allege that the banks in processing the PPP loans were paid origination fees by the federal government, but failed to share those origination fees with the other professionals, attorneys, CPAs, and other third-party consultants that were due a portion of the origination fees. And so this one is interesting. It's attracted some pretty heavy-hitting plaintiffs' firms. Mark Tannenbaum, Dick Hartputlian, and some others are involved in this attempt to basically sue every bank that's operating in the state of South Carolina. And they've made some creative arguments. And of course, the defense has mounted a solid defense and has also raised some pretty creative defenses. So we'll all be watching as these class actions unfold in South Carolina. You can see also we've got a class action against Charleston Southern, and David Mahan will speak more about the education cases, but this is a case in which students are suing their university, arguing that they paid the tuition, but they were not permitted to enjoy the full educational experience that they paid for. And so it's a breach of contract case at its essence. And then finally, I'll leave you with these business interruption cases. The business interruption cases, there's only 3 that we've seen that have been filed in South Carolina. These are insurance cases against the various different insurance companies. And the allegation is simply that the companies Coffee, Black Magic, and Fancy That were entitled to business interruption coverage for the COVID-related shutdowns, and that those claims or those requests for payments under the policy were denied. Now, it's interesting to know that those cases were part of a consortium of cases across the country that sought to be transferred to the MDL for handling pretrial and discovery matters. I actually was on the call or on the Zoom motion hearing before the panel on multi-district jurisdiction and got a chance to hear the arguments for and against transferring these insurance cases to the MDL. And it was a huge number of cases, thousands and thousands across the country. At the end of the day, the MDL panel rejected the request. And so those are not going to be consolidated for handling. They will be handled in their various states. And the reasons being that there were numerous factual nuances that differentiated these cases from one another. The court did not feel it was going to be efficient to go through the MDL process. And because the policies were so different depending on which insurance company and which policy was at issue, the court declined to do that. So we're going to see these business interruption cases continue in South Carolina, and they will be handled in South Carolina. And we'll have to just pay attention to see how the courts deal with these claims and whether or not there are any that are dismissed or settled. One final point before I pass this along to Tim Lindsay to talk about employment is there is an issue in South Carolina that I think looking forward, we can expect to see, and that is a increase in litigation related to commercial real estate. As you can, I'm sure, imagine, there are a number of tenants, especially in the retail space and otherwise, that have been unable to return to work, or at least unable to return to work as they were used to, and therefore unable to pay their leases, unable to pay their rents under their leases. And so I think we're going to be looking in the near future at an increase in leasing litigation. I've seen that just anecdotally as I monitor the cases on a daily basis. There's no specific reference to COVID, but I think we can all agree that many of these breach of lease cases are because of the pandemic and the shutdown. And based on that, where the tenants can't pay the leases, we're going to see landlords that can't pay the bank. We're going to see commercial real estate loan foreclosure. And then similarly, I think we're going to also see an increase in commercial mortgage-backed security litigation. South Carolina has about $3 billion in CMBS paper. And you can see based on this chart, the big three are lodging, office, and retail. And those happen to be particularly hard hit by the pandemic. And so when you look at this final slide, the delinquency rates, you can see the average here is just over 10%, but you've got lodging and retail, up over 15 and almost 25%. And so based on these delinquency rates, I think we're going to also see the CMBS market start to unravel a bit, and that could affect the South Carolina market as well. So that's sort of the basis, that's sort of the foundation of what we're looking at from a national and a state perspective. And what I'd like to do now is invite Tim Lindsay to talk to you about some employment implications and employment litigation in this COVID era.
Thank you, Robert. I appreciate being included in this all the way from Mississippi. I'm going to try in my 7 or 8 minute allotment to talk about at least 4 areas in the labor and employment arena that could easily by themselves probably take 30 minutes each. So I apologize in advance if any of it does seem rushed, as Robert mentioned, but certainly we would be available to answer any questions that may be to follow any of this, or even if it's something we do not hit on, we'll be glad to address those questions. And Robert, if we can go to that first slide, I want to talk about the National Labor Relations Act. It's important, and I think most everybody on this webinar would know that the NLRA applies to all employers, whether you have a union or not. There are a few that still don't understand that, but employees, even if they're not part of a union, can engage in concerted activity, which is a right protected under Section 7 of the NLRA. And what we've been seeing as a trend is more and more, 2 or more employees engaging in the concerted activity, primarily complaining about the safety of their work environment, which would fall under their Section 7 protected rights. Employers, unfortunately, a few that have felt like that it was just basically creating problems in their eyes, would terminate the employees, and they end up facing an unfair labor practice charge before the National Labor Relations Board. That in and of itself is probably the primary issue we're facing right now with some issues under the National Labor Relations Act. Nobody likes to go before the National Labor Relations Board. But when we do, we need to be sure that whatever reasons we're taking, it cannot be related to the concerted activity. The other primary problem with this, at least for you that do not have a union, is the union is using this as an opportunity to try to organize companies that currently do not have a collective bargaining agreement or a union representation, with the slogan essentially, "We are more concerned about your health than they are." And we're finding more and more that they will infiltrate your workforce and find at least 2, perhaps more, employees willing to test the waters and to try to force the employer's hand on some of these safety issues as to whether or not the employer is taking reasonable steps to protect these employees from the virus. And in several cases, we feel like it was frivolous or fabricated, but nonetheless, you spend time and your energy and your money in trying to defend an unfair labor practice charge before the board. So just be aware of potential campaign brochures or things like that the unions are trying to use to kind of crack the shell, so to speak, to get into those employers they've not been able to get into before. The other is the bargaining obligations that we have had to deal with under the NLRA, where an employer is currently under a collective bargaining agreement. And in some instances, the employers have taken unilateral measures to change working conditions and so forth that may be COVID related. Many times we've had to deal with the union who raised objections to the changes because they either felt it was a mandatory subject of bargaining or at least a permissive subject of bargaining that required them to negotiate the effects of those changes. The point primarily here being, if you do have a CBA, you might even have provisions in there that would allow you to do it because of either emergency or national circumstances that will allow unilateral action by the employer. The good thing is at least the current board is a little more lenient in that respect. That'll change, of course, if there's a new administration, but we have found it more, I think, efficient to sit down with the union in advance. More times than not, they've been more cooperative when we approached them in advance about some significant changes in the working conditions, workplace conditions, such as scheduling and so forth, to try to comply with some of the safety measures that the guidelines that have been issued by OSHA and others, which will take me to my next slide. Of course, we're all familiar with the general rule under OSHA of providing a safe work environment. And this has been a pretty busy topic for us in my practice group, primarily because when employers started returning employees to work about a month or 2 ago, we were having to implement plans in compliance with the CDC guidelines and as well as OSHA. The good news for you folks in South Carolina is you have this website that's theirs for the South Carolina OSHA, and I found it to be one of the more informative and helpful websites of the states that have their own OSHA agency. They provide guidelines for specifically for returning employees to work and also guidelines for preparing the workplace for COVID-19, prevention of worker exposure to the virus, coronavirus, and they also have a link to the federal OSHA that provides the 10 steps of all workplaces can take to reduce the risk of exposure. Those are all very helpful. If you've not visited that site, I would encourage you to do so. And I believe it would be absolutely necessary if you're considering preparing a COVID policy or rule, which we have done for many of our clients. And what we do in that instance is we ask the returning employees to sign an acknowledgement of that plan and rule, and it simply sets forth those guidelines and that they will comply with those guidelines. And in the instance that they don't, then they have violated a company policy like they have any other policy. And some disciplinary steps can be taken to deal with that. It also will avert, later we'll talk about litigation issues, but it also will avert, if you have such a plan in place, acknowledged by the employees, potential litigation. And we feel like that's been the most helpful thing when it comes to avoiding OSHA claims. We have already handled at least two-figure numbers of charges filed with OSHA by employees that have claimed unsafe work environment. In each case where we've been able to show a plan that was implemented in accordance with the guidelines that have been provided to us, we have been able to have those charges dismissed. So I would encourage each of you to look at those and to put a plan in place if one has not been already put in place for these employees that are physically at the work site. All right, my next topic is the WARN Act. The 60-day notice requirement. This is something we had to deal with early on in the COVID period, March and April. We had a lot of employers that were having to determine, are we going to close? Are we going to lay off? We're going to furlough employees. And of course, WARN requires a 60-day notice when you have an employment loss for certain numbers of employees. And a plant closing is just what it is, where if you shut down a facility that results in an employment loss of 50 or more employees, you've got to give a 60-day notice. Or if you have a layoff between 50 and 499 employees, you have to, that at least constitute 2/3 of your workforce, you have to also provide that 60-day notice. What we had in several instances is we had, instead of closures or layoffs of all employees, we furloughed employees where the intent was expressed, and we went ahead and provided a notice anyway, that the furlough was expected to not exceed 6 months. Because under WARN, if a layoff is less than 6 months, it's not considered an employment loss. Now, we are now currently dealing with situations where we've had employees that furloughed employees back in April and May. We're coming up on that 6-month period, and we're having to go and look to see if we can't recall all of them, who we need to recall, and be sure that we at least satisfied under that threshold of more than 50 employees that do not constitute 2/3. So it's just a matter of math calculation to be sure you don't get caught failing to give that 60-day notice. Under the requirement, there is an exception to providing that 60-day notice when it's an unforeseeable circumstance. Unfortunately, I've already seen a few things to suggest that now that we're this deep into COVID, it's no longer unforeseeable. I think the exception to that would be if, now that we've been several months into it, a business loses a contract that's significant to its operation, then I think that would certainly play, even if that loss of contract was due to the COVID situation. But the further out we get from March, the less likely it's going to be that we will be able to claim an exception under the unforeseeable exclusion. All right, next slide. All right, just litigation issues, both under the Families First Act and the FMLA. The first and foremost, denial of the leave has been by far the most litigation we've been involved with, and seeing employees that, unfortunately, we've had some employers to think that since they're not covered by the FMLA, they're not covered by the Families First Act that allows the leave, which is obviously incorrect thinking. Whether or not you're an FMLA employer, as that definition is defined, you're still required to give certain leave, the sick paid leave, as well as the expanded family medical leave for employees who have child care issues, or if their schools is closed and so forth. And now that we have situations that we're dealing with where employees have children that school has started back, but some are not actually being able to go to school. They're doing it virtually. So we're having to deal with that, and we're treating it as if they are having to stay home, depending on, of course, the age of the child. The secondary litigation issues that we've seen as opposed to denial of the leave itself has been the amount that they are due for either paid sick leave or the expanded medical leave, the 10 additional weeks. And that's still confusing to some. We have tried to deal with that in simple form. And if you look at the Q&A that the DOL issued back in April, I think it's set forth pretty simple, at least in the Q&A number 7, I believe it is, that sets it forth kind of clearly of what's due when and the amount that's due. The first 2 weeks of paid sick leave is full regular rate of pay, and with a cap of $511 a day, and then a cap total of the 10 days that they would get of $5,110. Then the additional 2 weeks, if somebody, 10 weeks, excuse me, if somebody needs to stay home with child care purposes and that sort of thing, they have 2/3 of their regular rate with a max of $211 a day, or no more than $12,000 over 10 weeks. So those were the two primary that we have seen in the litigation here. I think the Mackey case that David provided in his slide, I'm sorry, that Robert provided in his slides out of South Carolina dealt with the denial of leave case, but that represents the typical case that we have seen here in our region as well. I did want to point out the state of New York versus U.S. Department of Labor case. It's a Southern District, New York case, but it's significant in that the final rule of the DOL was kind of slapped around a little bit on several of the issues. Now, the only reason that's important, and we're not sure the extent to which that will be played in other jurisdictions. We do know, if y'all recall a few years ago, when the DOL attempted to institute the new wage and hour minimum wage and then the exemption level, salary level test for exemptions under the FLSA, a district court in Texas issued an injunction to it. And the DOL backed off of those final rules at that point. Here, the state of New York did not, this court did not issue an injunction, but we expect it to be used going forward by plaintiffs' bar and others to suggest that some of these rules need to be rethought. And if some of these rules, and I'll talk about those in just a moment, are in fact revamped, then we're going to have to go back and advise clients a little bit differently than we've been advising them before. The primary thing that this court found to be inconsistent and unenforceable was the work availability requirement, where under the final rule, if work was not available, in other words, if somebody had been laid off and so forth because of lack of work, they were not entitled to the leave. This court found that to be completely inconsistent with the purposes and spirit of the statute, and therefore shot it down. So the work availability requirement is under attack. We also had, and I probably for the healthcare industry, if there's anyone on the webinar in the healthcare industry, the biggest thing there was the definition of healthcare provider. The final rule was very broad. Essentially, anybody that worked for a doctor, a clinic, a hospital, or even a medical university was deemed to be a healthcare provider. The court found that to be overly expansive, reverted back to the traditional definition that the FMLA provides for an healthcare provider, which essentially will be your doctors, nurse practitioners, and those that actually are practicing medicals. It will probably exclude others. We don't know how far, but the court now is using the old rule and the old definition that has been provided for the FMLA for years. So unfortunately, if you're in the healthcare industry, you might want to read that rule and take it to heed. Okay, I think I've hit my 8 minutes, Robert. But like I said, I'm sorry if I rush through anything. I'll be glad to answer any questions later.
All right. Well, thanks, Tim. I appreciate that. And Kat, I'm gonna see if I can make you the host here so that you can show the next
Perfect.
page of
Well,
slides.
while you're doing that, I'll just say good afternoon to all of you. I'm Kat Carrington. I'm in our product liability practice group here in Jackson, Mississippi. I also do some appellate work, and I'm so glad to be here with y'all today. While the panel is focusing mostly on what the current litigation landscape looks like, I want to spend a little time talking about some of the legislative efforts that have been made to help prevent future litigation. So specifically, what's in place right now that you may be able to rely on to stop litigation in its tracks, and then other things that you may be able to rely on in the future, things that are on the horizon that we're hoping might possibly pass. So starting on the federal side, I'll talk state too, but we're going to start with the federal side. On March 17th, the Secretary of the Department of Health and Human Services, he entered a declaration essentially saying that the COVID pandemic constitutes a public health emergency. Now, he did that under an act called the PrEP Act. I'll share my screen with y'all so you can see what that acronym stands for. It's the Public Readiness and Emergency Preparedness Act. Now, this act has been around since 2005. It allows the secretary to issue declarations under certain circumstances that would immunize certain individuals and groups for engaging in various activities that are related to the public health emergency. And so that's what he did related to COVID-19. So what does this mean for you? Well, if you happen to fall within the parameters of the declaration, you are afforded some very broad immunities related to COVID-19. So what are those? What do those look like? So it affords covered persons, that's a defined term, for suit and liability under federal and state law for all claims for loss concerning the administration to or use by an individual of a covered countermeasure. There's one exception, and that's for willful misconduct. That has to be proved by clear and convincing evidence, meaning that the scope of this immunity is very broad, including what constitutes loss. We're talking death, personal injury, the fear of personal injury. You don't even have to actually be injured to get immunity from a claim related to your activities that fall within the ambit of the declaration. So how do you know if you fall within the declaration? Well, it says that covered persons are immune if they are engaged in recommended activities pertaining to covered countermeasures. So these are three very defined terms within the declaration. So you have to fall, your activity, who you are, and what you're working with, all must fall within those definitions to get protection. But because of how broad this immunity is, I would strongly encourage you, if you think there's a possibility that you or your client, the business that you're operating with or that you have an interest in, might have some benefits from this declaration, I would strongly encourage you to find out if you fall within the definitions for these three items. So recommended activities, we're talking about manufacturing, distributing, testing, developing, and distributing, administering, using covered countermeasures. The covered persons sort of falls along the lines of those activities, so manufacturers and distributors. There are also terms like qualified persons, and program planners that have broader definitions too. So it goes so far as to include suppliers, pharmacies, retailers, wholesalers, warehouses. The stretch is very expansive. Where it really gets narrow is when you think about what constitutes a covered countermeasure, because it may sound like something is obviously going to be covered, and it very well may not be because the definitions are so specific. So it includes things like drugs, devices, antivirals, vaccines, biologics that are used to treat, diagnose, cure, prevent, or mitigate COVID. But all of those have to fall within additional specific categories that are defined within the declaration and within the PrEP Act. And the secretary has put out some guidance to help businesses try to navigate this analysis and figure out if they fit within the parameters of it. But again, because the protections are so broad, I would encourage you to take the time to figure out if you might be able to benefit from this type of immunity from the declaration. So federal, what else do we have when it comes to immunities and limitations of liability for businesses? Unfortunately, that's it. The litigation, the legislation that has passed so far is not related to trying to protect businesses from personal injury types of claims in the COVID space. And so businesses are really struggling to figure out what they can really rely on to help them move forward. There's been a lot of talk about legislation, but nothing has passed so far. But we do have a bill that's currently pending right now. It's called the Safe to Work Act. It was introduced in July, and your outline that we've provided has some of the key points about what would be covered by this legislation if it passes. But generally, what it would protect is businesses, services, activities, accommodations, and related to claims for personal injury caused by actual or potential exposure to coronavirus, unless the business that we're talking about did not take efforts to comply with government guidance, if there was gross negligence or willful misconduct that was involved that caused an actual exposure, and the actual exposure caused a personal injury. So a lot of hurdles that a plaintiff will have to overcome if this legislation is put in place. But right now, that's all we've got. So the federal side has not done very much to try to protect businesses right now. So states are trying to take up the slack. This is a list of 33 states that you see on your screen that have either entered an order, some type of governor's order, an executive order, or they've passed some type of legislation to try to protect businesses as they are operating right now in these very unprecedented times. Unfortunately, a lot of what these legislative efforts and these orders include is limited to the healthcare industry. So there's still just a significant gap in terms of what can be relied upon by businesses going forward. And you'll see South Carolina is not on this list. The good news is that there may be some hope for South Carolina. Last week, there was some legislation that was introduced, the South Carolina COVID-19 Liability Safe Harbor Act. It's a lot of words. But it's now just in committee, so very early stages. We'll see what happens. The outline also that we've provided gives you some more of those key points about what would be covered by this act in the event that you're able to take advantage of it. But the key issues, it's going to cover a variety of businesses, profit, nonprofit, government entities, and all of their employees, officers, agencies, from any claim arising from COVID-19 that's related to premises, operations, products, services, acts, omissions, and efforts to prevent or delay the spread of the virus. So it's very broad sweeping. So having this pass would just be tremendous for all of you in South Carolina. The one kicker with this is that in order to be able to take advantage of it, you must reasonably adhere to public health guidance to be able to get protection. Which goes to the next thing I want to talk to you about what can you do now, knowing that there is no legislation really out there that you can hang your hat on. What can you do? First, I would encourage you to call your legislators, write to them, try to encourage them to pass this legislation or something similar so that you in South Carolina really have something in your pocket that you can rely on whenever the lawsuits come, when they come, because they're going to come. This pandemic has been going on for several months now. We don't know when it's going to end, and claims are ripening. So it's just a matter of time before they get filed. And it would be great if you got something you really can rely on, set in stone, that's statutory. The other thing that you can do, though, follow government guidance. We've been talking to y'all about OSHA. You've heard about CDC. The FDA also has guidance out there. And the reason we're talking about that is because we're in unprecedented times. There's so much we don't know about this virus. And what else can we do but think about rely on, that's all we have to really to rely on right now. The good news is that this concept of relying on government guidance is not new. It stems from a defense that we call "the government said I could." Here's a quote from a case from more than 50 years ago from the Supreme Court. It says, "Ordinarily, citizens may not be punished for actions undertaken in good faith reliance upon authoritative assurance that punishment will not attach." So essentially, if the government tells you this is what you should be doing, you should not be held liable for when you follow it. The good news is that the cases that have come out so far since we've been in the pandemic that touch on following guidance seem to be following this defense. So if you're a business that is reasonably taking efforts to follow applicable guidance, the courts are acknowledging that and they're protecting the businesses that are doing it. On the flip side, the businesses that are not taking those efforts, they're getting hit. We've seen TROs get hit against them, and requirements that they engage in certain activities to ensure that they are bringing their facilities up to speed to match that. So what you can do right now, the takeaway, find out what guidance applies to you, your business, your client's business, and follow it as closely as you can, because the likelihood is that down the road, it's going to provide you with a pretty strong defense when the litigation comes your way. So I'm going to pass it on to Mitch Morris now, who's in our Virginia office. He's going to touch a little bit more on this subject, and he's also going to talk about some common law areas of interest. So thank you so much for the opportunity to be with you today. Let's see, I'm going to see if I can make all this flow smoothly.
Excuse me.
Oh, really? Oh, yep. Okay.
All right. Hi, everyone. This is Mitch Morris in the Richmond, Virginia office. It's a pleasure to be here with you today. Although I'm not a South Carolina lawyer, I am fortunate enough to be married to a South Carolinian who is a lawyer, and like you, here in attendance is an in-house corporate counsel here in Richmond. So, what I want to address today is what the non-employee claims against businesses that are not covered by the existing immunities, whether federal or state, might look like. And in this vein, it's still very early. Unfortunately, we haven't seen the tidal wave of common law type personal injury litigation that I think many of us anticipate and still expect. But I think that it is nevertheless likely to be coming. So I think the best way we can all be prepared to one, prevent or forestall claims, and two, to robustly defend them, is to plan ahead and take time now to analyze what these claims might look like and what defenses might be available. So I think the most likely source of any common law claim is, of course, common law negligence. And I think when we kind of go through your classic law school exam, point by point analysis of what a negligence claim might look like, the good news is we see that we will likely have many, both many and robust defenses to potential common law personal injury claims by non-employees. Of course, the first element of any tort claim, any negligence-based tort claim, is a duty of care. And for purposes of this discussion, I'll kind of divide the world into two hemispheres. What I'll call medical businesses, which would include hospitals, nursing homes, assisted living facilities, et cetera, and then non-medical defendants, which is essentially everyone else. I think medical defendants present their own unique circumstances and are probably somewhat obviously at a higher risk for liability related to COVID spread. I think the good news for medical defendants is that I believe in most states, either prior to COVID and certainly post-COVID, there are either legislative or executive immunities that have been proclaimed. So on the one hand, while medical facilities will likely find themselves the most vulnerable to claims, they will likely have the most robust defenses in terms of immunities under state law. So I'm going to focus on the non-medical world. And, really whether a duty will be found to exist, I think will in large part determine on the law of the particular jurisdiction where the claim arises. Most jurisdictions either follow a foreseeability test to determine the existence of a duty or a policy decision type test. I think in places where foreseeability is the crux, the existence of a duty may be more likely to be found versus where courts simply say this is a policy decision of where we think fair liability should begin and end. But under either test, I think we can safely start from the proposition that there is really no, I think, prevalent authority existing today that would support the imposition of a duty on a non-medical defendant to protect a non-employee from the spread of an infectious disease, which that company's own negligence did not cause. And we certainly have precedent in the infectious disease space, and I've noted it here on the slide. Foodborne illness cases, certainly cruise ship cases with the norovirus, and Legionnaire's disease type cases that result from improper maintenance of water pipes, et cetera. And in each of those categories of cases, what you see, the common denominator is that the defendant's alleged negligence or conduct really is what created the situation that led to the outbreak. I think in contrast, no single business or organization, negligent or otherwise, led to the outbreak of the coronavirus. Your local Harris Teeter didn't cause this pandemic to spread. And I think that will be a significant point to distinguish existing cases from duties that putative plaintiffs might seek to impose. Step one, I think, is to fight the very existence of any duty in this type of litigation. Step two is even if an organization were to be presented with an adverse decision saying, we think we're going to recognize a duty in this circumstance. There's still the fallback issue of, can we apply that duty to conduct that happened before this decision? It's this issue of retroactivity and fair notice. In other words, if somebody sues me for something that I failed to do in February or March or April or May, and in July, August, or September, the court says, we think there's a duty. Can you really fairly impose that duty to conduct that happened before it was clearly announced? And we've included in your packet, it's the very last article that really goes into that very issue. And I would encourage you to consider that. And really there's kind of two pieces of it. Each state has its own test for whether to retroactively impose newly announced tort duties. But then there's also really a constitutional due process issue that we should be mindful of. So first step, again, duty, very good arguments that there really shouldn't even be a duty recognized in these cases. Next step, if there is a duty, what does the standard of care look like? As both Tim and Kat have noted, it likely will be either the CDC's or OSHA's or similar state guidance. And, particularly because this is such an unprecedented, extraordinary situation, whereas oftentimes, your traditional, I complied with the applicable regulation won't be a complete defense to liability. I think here the circumstances are so extraordinary and novel that the case for relying and complying with this guidance as an absolute defense to tort liability becomes particularly compelling. And again, Kat and I have written some about that, and those materials are included in the packet that you've been provided. Next issue, perhaps the Alamo defense, except unlike the Alamo, I think this defense will prevail, but it's kind of the line in the sand. And even if everything else exists, you've got the challenge of causation, which is often a problem, particularly in toxic tort litigation. You've got general causation, which is, can my product for this particular circumstance that exists in my premises even spread the coronavirus? And frankly, I think where we sit today, the science is still completely unsettled on that. We really don't know exactly how it spreads. But even if there is reasonable scientific evidence that a particular product or circumstance can lead to the spread of the virus, a plaintiff will still have to show that that is actually what caused their contraction of the disease. I've quoted here, it's an old Fourth Circuit decision, but essentially assuming that there was a duty and that the defendant created the problem, the claim still failed because of a failure of causation. In preparing for this presentation, I learned something new, which is this doctrine of faire nascere, which is a very old common law doctrine, essentially saying that premises owners are not responsible for harm caused by wild beings. And in this case that we've cited from Texas, it was applied to find that a premises owner cannot be liable for a worker's contraction of West Nile disease caused by a mosquito. Here with the coronavirus, we don't necessarily see mosquito-borne transmission, but it does raise the issue of whether this doctrine might provide an additional defense. I know I'm kind of rushing through here, as Robert said, a lot to cover, but I do want to hit this concept of non-negligence causes of actions, which frankly has given me the most concern since the outbreak of the pandemic. Again, I truly believe that there is a robust array of, or will be a robust array of these defenses to negligence claims. But I've got to say, I've been concerned from the outset about non-negligence claims, and in particular nuisance type claims. And we've got two types of nuisance claims: public nuisance and private nuisance. And I've got the restatement definitions there. We've already seen, a handful of very prominent public nuisance suits that have been filed. Now, to date, these have been filed by employees. There was one very high-profile, well-covered suit against McDonald's in Illinois State Court, alleging that its corporate-owned stores were not adequately protecting employees. And then there has also been a suit filed in federal court against Amazon in the Eastern District of New York, related to workplace safety in one of its distribution facilities. And I can provide the case information on those cases if people would like. But what we see, particularly in the Amazon case, where a motion to dismiss has been filed, I think predictably and rightly, Amazon is disputing the notion that employee safety can rise to a public nuisance because, of course, it's unique to that workplace and not necessarily a right common to the public good. So, I think, and there's also this notion that OSHA has primary jurisdiction, which we've seen in some decisions that are cited in the materials. So I think employers, again, will likely have strong defenses to claims brought by employees, whether under OSHA primacy, workers' comp bars, or just the inapplicability of public nuisance. But I think what every business should be mindful of is the potential for a nuisance claim brought by a non-employee, in the specter of insureds whose business interruption claims are being denied by their insurers, suddenly finding themselves the subject of nuisance suits by their neighbors. If one particular premises or business has been alleged to have particular problems and linked to particular outbreaks, could they be a target of a private nuisance suit by a neighboring business or by the neighborhood as a whole? I think that's fortunately something we've not seen, but I think it's something that we need to be mindful of. The last point is consumer protection suits. And I think we've seen where other claims won't get a foothold, that plaintiffs will often rely on the very expansive protections of state consumer protection laws. I think we now see in restaurants and hotels, advertisements about the quality and frequency of the cleaning of the premises, and could those types of proclamations and signage give rise to a consumer protection claim? So I think companies need to balance the desire to show their customers the precautions and safety that they're taking with the likelihood that those very same proclamations could expose them to additional liability. So I know I've gone a while. I want to kick it to David before we run out of time. And so David, one final point. What we have seen is in the handful of personal injury claims that are being filed, some pretty novel arguments for removal based on CDC guidance and the PrEP Act, based on federal question and federal officer concepts. I think those are a stretch, but we will see how they play in time. So let me pass this to David.
Thanks, Mitchell. Can you hear me? Great. Thanks, all. Very much appreciate being a part of this. I'll be very quick. The information we have is very fast and furious. In the last 6 months, from the college and university setting, we have seen over 200 lawsuits filed against colleges and universities 200 lawsuits filed against colleges and universities. And that averages into over 30 suits per month, over 1 per day. And what we're seeing now is that if your favorite college or university hasn't already been sued, they probably will be. There's over 4,000 colleges and universities in the United States, and over 1,400 ranked by U.S. News and World Report. Sounds like a small amount so far, but it's happening a lot. One of the plaintiffs' law firms involved in the suit against our home university, the University of Colorado, is the Anastapoulos firm. I suppose some of you are familiar with. The catchy slogan, "Car wreck, don't scream, call Akeem," has now been turned into a catchy car wreck slogan to class action lawsuits against some of the most well-renowned universities and colleges in the United States. They include the University of Southern California, Johns Hopkins University, Vanderbilt University, and major public institutions like Penn State, Michigan State, and Texas A&M. So what's behind these suits? What's basically going on are the common themes of breach of contract, misrepresentation, and unjust enrichment. And the essence of these suits we'll see will probably have a wide-ranging effect in other businesses and organizations, because if plaintiffs' attorneys are also inventive, they're also copycats. And so I would expect, and what I'll explain in just a moment, you'll see is what's transmitting from colleges and the universities will continue on to other businesses. In the college and university setting, the simple argument, and dovetailing off of what Mitchell had argued, is that one of these the arguments is what you promised us was an educational experience of in-person learning. And despite COVID and despite your best efforts, that didn't happen. And interestingly enough, these lawsuits have established the fact that they support the university's closure of these events and college campuses, yet they argue that what the university setting promised but failed to deliver was an in-person learning. The universities have almost uniformly opposed the refund of tuition. Basically, they've gone on record to say, we've tried to maintain the best educational experience. We've expended more dollars to make university classes available online. And we believe that when we give the college credit for those courses, the agreement has been engaged in and our duties have been met. So far, most of these cases have just been in an answer stage, and the plaintiffs have a whole host of burdens to overcome, such as the class action certification. It might sound like most of the students have a commonality in connection with getting refunds for athletic fees, bus fees, health department fees, and whatnot. But we pose that the English major and the history major might not be very similarly situated to the engineering major, who might have missed out on a whole host of labs and whatnot. So these are very complex cases, and they involve state-specific defenses, including possibly force majeure, depending upon the university's contracts and agreements. In Colorado, there's a common law defense of impossibility of performance, which, if met, could excuse the university's performance in the way in which it's done. But what I'll see, and I'll wrap up with, is what we have here is a wide range of cases that have involved a promise not met. And what we're going to see is any business that's involved in a promise, and especially in prepayment, be it the leisure setting, travel, to what we see in the ski areas. If you prepay for a ski pass and that ski pass or the ski mountain is closed, there's going to be a claim for refund for a promise unmet. So I'll leave it with that. And I don't know if you have time for questions, Robert, or I think our time's probably up.
Well, I'm afraid we have used up our time, and I want to be careful of the participants' schedules. I'm sure everybody's got a busy day ahead of them. What I'd like to reiterate, which Mitch and Kat and others have referred to, is that we are providing you with a copy of this slide presentation, as well as a detailed outline and a compilation of about 15 different publications from our firm dealing with these COVID litigation issues. And so all the participants should get that emailed to them by the ACC. And if you have any questions, please follow up with us. We'd welcome the opportunity to have a conversation with you about any kind of COVID-related litigation or issues. So thank you to the ACC for having us. It's been a real pleasure to be here today. Thank you for attending.
Thanks, Robert. And everyone, just please be sure to answer that survey question at the end. We will have a recording of this webinar, as well as the materials that Robert referenced, up on the ACC South Carolina website too. So we'll have that up very soon, and you can check back there. Thank you.